We'll start just 2 more minutes.
Good afternoon, Professor Subramanya, sir.
Yeah, good afternoon to you. Namaste. Namaste. Namaste.
Mahavir sir has joined or not? Balaji, are you there?
Yes, sir. Yes, sir. I'm there.
Okay. Hello, Balaji. How are you?
I'm good, sir. I'm calling Mahavir, sir, no?
How are you, Anupam?
Yes, I am good. Thank you. How are you,
Your
ma'am?
leg is fine. I am fine. Your leg is fine now?
Not fine. Still, I am recovering. Plaster is there. So it will take another 1 month.
No.
Mahesh sir is joining in a minute. We'll start. Okay.
All right. Yeah. Okay.
Dr. Bala. Dr. Bala.
Sir.
Uh,
Okay, sir. We'll start the meeting.
Okay. Yes.
Start
Yes.
the program.
Start.
Simran?
Yes, sir.
Yeah, go ahead.
A very warm good afternoon to one and all present here. I, Simran Mehta, student of second year LC2, welcome you to the Golden Jubilee celebration of LC2. I welcome you all to the special webinar on WTO and developing countries. So why do we need WTO being a developing country? India being a very vast and a diversified country, being a developing country, why do we need WTO? The answer is we need to protect our economic interest. We need to protect our economic sovereignty. Being as we have seen in the past recent events, how crucial it is to protect our economic sovereignty in a wartime and in a peacetime. But few past events, recent past events has made us more realization for us to protect our economic interest first. So WTO provides us the very basic fundamental questions of international law. It provides us to help in a free trade. Being a developing country, we don't have. It is not easy for a developing country to do a free trade. Its implication can be seen in our negotiation tables. But WTO provides us some of fundamentals for a free trade. Like PSNR, domestic content subsidies are some contestation where developing countries are facing visible negotiations. Trade reality is still far dream for a developing country. Participation of developing countries in trade hasn't improved as such under WTO regime. Situation of developing countries is very different from developed countries. So how far homogeneous rule is productive for a developing state has always been a matter of debate. So I would like to thank our director, Professor Mahavir Kalon, who has provided us with this great opportunity to celebrate this special moment. Thank you very much, sir. Now I would like to invite our Professor Mahavir Kalon to grace us with his kind words and to celebrate this special occasion with our guest member. Over to you, sir.
Thank you. Thank you. Respected, distinguished guest, Professor Dr. T.R. Subramanya, our year's LLB program to promote students activities at the center. A number of committees has been constituted. These committees include moot court and debate committees, seminar, conference, and extension lectures, general committee, delegate committee, placement committee, and alumni committee. There is an active participation of students in the members, several activities, regular basis throughout the year. Drums are parts of the participate. From
We'll have some network connectivity issue. We'll ask sir to join the program. So he is joining in a minute.
now, am I audible?
Yes, sir. You
Yes,
are
yes,
audible.
sir.
Go ahead.
Hello,
Yes, sir. You
Yeah.
are audible.
hello.
Yes, sir, you are audible now.
Yes, Bala, am I audible?
Yes, sir. Go ahead.
Hello,
Yes, sir. You are audible.
hello.
You are audible, sir. Go ahead.
Yes, yes. Go ahead.
सर आप ऑडियो
Hello.
Yes, sir. Go ahead. You are audible.
Okay. As you know that we are talking about the committees, like the teacher, members, and students volunteer organize several activities throughout the year. The S.K. Puri Memorial Moot Court Competition of Law Center 2 65 is an annual activity in which terms from all parts of the country participate. The seminars and lectures committee, apart from organizing seminars, conferences, and workshops, organizing lectures of legal scholars from all over the India and abroad. Law Center 2 is celebrating its Golden Jubilee in this year, and this event is a part of celebration of Golden Jubilee. we are having distinguished Professor that Professor Dr. Subramanya is currently serving as the Dean of CFR. From both of our daily and the guest and
sir, with the permission of director, program director Anupam sir. Anupam sir. Anupam sir, I am audible. I'm audible. Anupam sir, I'm audible.
Yes, sir. Yes, Balaji sir, you're audible. Please go ahead.
Sir, on behalf of the professor in charge, I will invite the speaker. Okay. Okay. Yes, sir. We have today we have with us, our professor in charge is facing some internet issue. So
Okay.
on behalf of the professor in charge, I will invite the today's speaker. So we have with us Professor Dr. Subramanya, who is presently serving as the Dean of CMR University School of Legal Studies, Bangalore. So after serving as the coordinator and research fellow at the Center for Regulatory Studies, Governance and Public Policy in the West Bengal National University of Judicial Science, Kolkata. So prior to this, he was the Vice Chancellor of Karnataka State Law University, Jubilee, Karnataka. And he was also been a professor of international law at West Bengal National University of Judicial Science, West Bengal. And also he served as a Vice Chancellor in charge of Bangalore University, Dean and Chairman of the Faculty of Law, Bangalore University, and has also served as a Registrar Evaluation of the Bangalore University, Registrar in Charge, Administration of Bangalore University, and also at the international level, the Professor Subramanya has served as a legal advisor to the Kingdom of Bahrain for 7 years. In this capacity, he acquired the considerable knowledge of laws and legal system of Gulf Cooperation Council, state, and in the practical application of international law at the municipal level. The Professor Subramanya has also obtained a Master of Philosophy and the Doctor of Philosophy in International Law from the School of International Studies, Jawaharlal Nehru University, New Delhi. Sir, on behalf of the Law Center 2, on behalf of the professor in charge, on behalf of the Delhi University, I will welcome you for this program. Thank you. Simra?
Shall I start now?
Yes, sir.
Yeah. Respected Professor Mahavir Singh, Professor Anupam Jha, Professor Ekalavya Anand, Professor Santosh Upadhyay, and Professor Balaji Naik. I deem to be it a great privilege to be here to deliver a lecture on behalf of the Delhi University campus of Delhi University School of Law for the Golden Jubilee celebrations. Now, without mincing any words, I just come to the topic itself. Now, when we take up the WTO as an institution, I just intend to bring home about the WTO itself for about 10 minutes before I speak about the developing countries and its place and their relationship with the WTO. Now, prior to the establishment of the WTO in 1995, there was an organization which is called General Agreements on Trade and Tariff. And this agreement, General Agreement on Trade and Tariff, came to be established in the year 1947. Now, it was functioning very smoothly. It was functioning very efficiently as well. And in spite of several problems that faced in the late 1970s, it was functioning smoothly. And it was meant only for the purpose of, remember, trade in goods. And as far as trade in goods were concerned, it was doing very well. But then there was a lot of problems within the General Agreements on Trade and Tariff. One such problem happened to be, it did not have an enforcing mechanism. Decisions were taken, and these decisions, when it were taken, it was left to the discretion of the concerned state to implement it. Initially, when the members of the United Nations as well as the GATT members were limited, it was possible because they were in a position to take up the matter seriously and could implement the decisions of General Agreements on Trade and Tariff. But then over the years, what has happened was, here and there, several other issues surfaced as well. In circumstances such as this, they thought, the members of the international community felt that the entire GATT agreement has to be revised or reviewed. With the result, on September 20th, 1986, the first meeting was convened. And when the first meeting was convened, there were members of the developed countries, members of developing countries, as well as the least developed countries. And these members started, remember, discussing the issues. When they started discussing the issues, several other issues came to the fore. And it was not thought of, because some of the states, when they put forth their views across in the meetings, the other members felt that these are genuine. And these genuine issues are to be tackled, come what may. So with the result, although it came in and it started for resolving a particular issue relating to trade, many other issues came in. One such issue happened to be an issue relating to services. Another issue happened to be relating to intellectual property rights. Then the enforcement mechanism, which was lacking. These are the major issues came up there. Afterwards, many, more than 25 issues were discussed by the WTO itself. Now, what began on September 20th, 1986, met annually for almost 8 times. Having met 8 times, they were able to conclude what we call as the WTO agreements. Now, it is an international treaty, and this treaty was signed at the Turkish city of Marrakesh. It was signed on 14th of April, and it came into force from January 1st, 1995. Now, the WTO as an instrument, one instrument, it is an international agreement with the 16 articles. And all the states who intend to become a party to the treaty had to ratify it through their municipal constitutional law. And when once it is ratified, it would come into force, and it has to be effectively enforced by the concerned state through the constitutional machinery of that state. So initially, there were 117 states who signed the agreement. I'm just telling you, in the Marrakesh city of the Turkish capital, 117 states signed this. But thereafterwards, the numbers grew, and today it has nearly 170 members as members of the WTO. Now, when we speak of the WTO as an organization, now what exactly are the framework or the basic structures within the WTO? When we take up the basic framework of the WTO is basically you have what we call as the Ministerial Conference. Now, the Ministerial Conference of the WTO is competent to take important policy-making decisions. And in this Ministerial Conference, all the ratified states, the states which have ratified the WTO, are members of it. And not only they are members of it, they participate in the Ministerial Conference meeting, which is held once in 2 years. To be very precise, most of the ministers, trade ministers, or the ministers of trade and commerce are part of what we call as members of the Ministerial Conference, because it takes policy decisions. Now, thereafterwards, you have another conference, another body which is called as the General Council. Now, when we take up the General Council, remember, is also represented by almost all the members of the WTO who have ratified the agreement. Now, when the Ministerial Conference is not in session, because it meets only once in 2 years, all the policy decisions which are very relevant are taken into consideration and implemented. And the implementing agency is generally called as the General Council. Now, after the General Council, we have what we call as other important bodies. And when we take up these important bodies, there are a few of them. Now, the first one is what we call as the Dispute Settlement Body. So the Dispute Settlement Body happened to be a body which is established for the resolving of disputes between states. And these disputes must be related to trade disputes only, not any other thing. Now, this dispute settlement mechanism and its weaknesses, I shall tell you at a later stage how it harmed the growth of the developing countries and their trade. Now, then we have what we call as the Trade Policy Review Body. Now, the trade, remember, or the volume of trade is not constant between states. When it is not constant between states, it has to be reviewed annually. And this is being done by an organ within the WTO. And there are several efficient members who are qualified men and competent enough to deal with this matter. Thereafterwards, we have the Council for Trade in Services, the Council for what we call as TRIPS, trade-related aspects of intellectual property. Then we have the what we call as the subsidiary bodies. Now, for example, the Council for Trade and the Council for Trade in Goods and Services, the councils for trade-related aspects of intellectual property rights are empowered to appoint its own people and adopt resolutions and get it past the General Council and ultimately by the Ministerial Conference. Now, a lot of other things are there, and when we go further, we have other bodies, what we call as the Committee on Trade and Development, the Committee on Balance of Payment and Restrictions, and the Committee on Budget, Finance and Administration. Now, these are the major committees within the WTO. Now, in addition to that, the Committee on Trade and Development reviews the trade policy with the least developed countries and developing countries every year. Now, the budget is actually prepared by the Committee on Budget and Finance. Now, initially, the budget platform is processed through the Director General. And afterwards, the budget is being prepared, and again, it will be looked after. Then it will go to the General Council, and ultimately, it will be approved by the Ministerial Conference. Then we have what we call as the other bodies as well. Now, these bodies, which is called mainly Secretariat. Now, you have a Director General of the WTO, and he is appointed by the Ministerial Conference. And this person holds office for 6 years. And it is in his name, the letters are being given of employment. All employment letters are issued in his name. And thereon, they serve. And they may go on their duty to different parts of the world. And when they go to different parts of the world, they are entitled to have privileges and immunities. And these privileges and immunities are to the extent required for the purpose, for discharging their obligations. Now, when we take up the WTO Secretariat, the WTO Secretary General holds, remember, he is appointed as the Secretary General, but he is the one who exercises both the administrative functions as well as the executive functions. Because when I speak about the executive functions, he is the chief spokesperson of the WTO. And whenever he makes a statement, his statements are actually speak about the policy decisions of the World Trade Organizations. So since 1995, until this day, it has been functioning very well. Although there are lots of complaints, remember, and these complaints generally are addressed to the WTO and the international community by the least developing countries and the developed countries. I just intend to bring home a few of them so that we will come to know whether these are genuine, and if they are genuine, why resolution is not being taken by the World Intellectual Trade Organization. Now, the first issue happened to be the linkages issue. Now, when I speak about the linkages issue, always remember the WTO is a trade organization. And when it is a trade organization, World Trade Organization, why? Remember, the WTO should interfere in matters pertaining to labor. Now, in the social clause, naturally, it will go to the extent of interfering in labor matters as well. Now, when we speak of the labor matters, as early as 1921, the International Labour Organization was established. And it has asserted its power. Not only did it assert its power, it has adopted conventions. There are as many as 189 conventions adopted by the International Labour Organization. In addition to these 189 conventions, there are as many as 202 resolutions adopted by the ILO. The power of the ILO in regulating the working class is immense. Remember, it knows poverty is danger to prosperity, and for which it has been working to overcome these things. And the international labor codes are binding, and the conventions which are adopted naturally is binding on states. When such an activity is carried on in promoting and regulating international labor standards by the International Labour Organization, where is the need for a trade organization in interfering in the labor matters? This was a major question that was raised. And this question, when it is raised, remember, naturally, it would affect the developing countries as well. For example, take it this way. Now, a particular state which is poor, a state which is in a developing stage, now it intends to get a loan from the International Monetary Fund. And when it takes a loan from the International Monetary Fund, although the International Monetary Fund is not supposed to put a clause on this, it puts a clause on labor standards. And the labor law is applicable there. And the point at issue is, remember, you are taking a loan for the development of the economy. And when you take a loan from the World Bank, you are putting a social clause and a labor clause. And naturally, it is a hindrance to the growth and development of the economy itself. Now here, we have the WTO, which is interfering in all matters relating to labor. Now the second organ happened to be the United Nations Environment. Now when we speak of environment essentially is not the task for which the WTO is cut out. The role of WTO is to promote and protect trade, and it is see that everyone, both the least developed countries, the developed countries, and the developing countries get a share and get a benefit. In the event of exemption of taxation, all of them should enjoy universally and unilaterally. That is the purpose of the WTO. Now, here is a case wherein WTO is interfering in the matters relating to environment. Now, if you just think of the history of the environment, now you have what we call as the United Nations Environment Program, UNEP. UNEP is a subsidiary organ of the United Nations, which was established in the year 1972. And thereafter, it has been functioning very well. If I can go to the extent of pointing out, there are as many as 320 treaties, international treaties, which are adopted by the United Nations Environment Program in the area of environment. And remember, it is doing wonderful job. Now you think of the World Charter for Nature, or you think of the Meet on Sustainable Development, and other things. Since it is not a forum to speak on environmental law, I don't wish to touch upon. Now, when this is done by the United Nations Environment Program, why an organ which is established only in promoting trade should champion this cause? That was another criticism which is leveled against WTO. Now, the third criticism happened to be, you see, you have, for health matters, you have the World Health Assembly or WHO, World Health Organization. World Health Organization is functioning under a constitution of its own, and it has a director general of its own. And when it is functioning under a constitution of its own, why an organization which is meant for regulating and promoting and protecting international trade interfering in matters of health? But this is not a welcome sign at all. And many writers have written books on that. And the WTO went to the extent of, in the initial stages, went justifying it. And afterwards, remember, when the criticisms were huge, it went to the extent of finding out it is not interfering in these matters. But here and there, when conditionalities are put for protection of environment, protection of health and other things, it is unnecessarily and uncalled for on behalf of the WTO. Now, you might be knowing, as far as the technical matters are concerned, you have organs within the United Nations system. For example, we have what we call as ISO for safety standards, regulatory standards, and Codex Alimentary Communities, Codex Alimentary Commission, we have for establishing technical standards. When these are there, already established, already is functioning, already is working, along with the institutions, there is no need for the WTO to interfere in matters of this kind, is the major criticism that is being leveled against. Now, the second one is, you might be knowing, I shall just tell you just 2 or 3 minutes of the history of IPR. Now, most of the IPR legislations came in this country after 1972. Prior to that, remember, there was no serious legislation at all, although there was one Paris Agreement. Now, in situations like this, most of the developed world, the so-called developed world of today, did not have IPR legislation. They did not have IPR legislation, and they were inviting everybody freely, so that either manufacturing or access to books could take place in their country. Now, for instance, I can just tell you the state of Switzerland, the most advanced country, did not have an IPR legislation till 1967. And this is the state of Switzerland. The state of Germany did not have an IPR legislation till 1979. And the state of Italy did not have a legislation till 1991. Now, this was the state of affairs. For example, today they boast of their IPR. But then these states are the first one, remember, who violated all of them and allowed everything to come to their country. And when everything is complete, they said it cannot be taken and nobody can access unless you pay through your nose. Now, you may be knowing, the TRIPS agreement came in. And a TRIPS agreement, remember, the moment you sign the WTO, you become part of the TRIPS agreement as well. Trade-related aspects of intellectual property rights. Now, when these are taken there, remember, most of the writers, especially the writers from the developing countries, pointed out every TRIP agreement and every TRIPS clause must take into consideration public welfare criteria. Now, the present TRIPS agreement does not take public welfare criteria at all. Now, what do you mean by public welfare criteria? Now, when I speak about public welfare criteria, plenty of instances or illustrations can be given. Now, first is, remember, you have to take into consideration whether a particular item, if protected under IPR, should reach its benefits. Now, when I speak of this, remember, naturally you take the instance of some medicines which are being prepared. Now, there are certain medicines, the excess of which to every citizen in a country is almost essential. And remember, most of the developing countries, including the state of India, before becoming a party to the TRIPS, they kept out certain essential medicines out of the IPR. And these essential medicines are very much essential to protect the citizens of the country. Now, today, they have become part of the WTO agreements, and have become part of the WTO agreement, they have to protect it. Now, essential, remember, to save the life-saving medicines, which are to be, remember, protected under, if they are protected under the IPR, will they be in a position to be given to every citizen when he is suffering from a particular disease like fever, or a disease like malaria, or a disease like typhoid, or a disease which may be several kinds. In each state, you have different types of monkey fever. For example, in some places here you have such diseases. Now, because this has to be kept out, and only when it is kept out, everybody will be in a position to, remember, in a position to make use of these medicines. Vajpayee, Atal Bihari Vajpayee, when he was the Prime Minister of the State of India, he pointed out, we will become party to the TRIPS agreement only by taking into consideration the availability criteria and the affordability criteria. First is the medicine is available. And when the medicine is available, remember, it is our duty to see that it is affordable as well. And everyone should be in a position to make use of these medicines. This is not happening. I will give you 3 or 4 illustrations so that you understand the point better. Now, one instance happened to be an instance of the state of Thailand. In the state of Thailand, a few years ago, it was infected with AIDS. When it was infected with the AIDS, what has happened was an American company came forward, and afterwards it prepared a kit for the Thai nationals infected with the AIDS. And this kit was for a particular year, 1 year, and they had to pay about $10,000 or so, and somehow they swallowed it. But it was telling on the health of the economy of the state of Thailand. In circumstances such as this, the very next year, the state of Thailand, remember, prepared a kit by using its own, remember, indigenous sources. When it started using its indigenous sources, naturally, the state of United States intervened on behalf of the company which supplied the medicine the previous year. And it used the WTO as well. And it went to the extent of saying, you have violated the what we call as patent rights, and you don't have any right to prepare any medicine. And they warned, our trade relationship will come to an end, I will impose embargo. Now, the Thailand essentially depended at that time for 25% of its export with the state of United States. And because of preparing one medicine just to save the lives of millions in the state of Thailand, remember, it bushed to the state of United States and ultimately abandoned the program. Don't you think this is something, a mentality which was not expected and visualized when the WTO came into force? Now you might be knowing the objects of the WTO. I just wanted to bring it at the appropriate place. The object of the WTO is, first is raising the living standards for the people. So higher levels of living standards. Then afterwards, higher levels of employment. Everyone should have employment. Then growing volume of what we call as real income. Everyone in this income should grow when once WTO comes into force. Then expanding the production of goods and services. These are, remember, essentially spoken. But then thereafterwards, remember what is happening now. You have spoken as part of the objectives, but then most of it activities are, remember, against the objectives. That is how it is functioning. Now, another illustration happened to be an illustration that has taken place in Guatemala. Now, the UNICEF has given the statistics. I'm speaking through the statistics. UNICEF has gone that far in saying that every year the infant mortality in the state of Guatemala, a banana republic, is almost 1.5 million. 15 lakhs of infants, children die. And they die out of diarrhea. And they die due to the infant formula substituting the breast milk to be given to the children. Now the infant formula substitution to the breast milk was prepared in the state of United States. And remember, and this formula was taken and afterwards in the state of Guatemala, in the name of the company, it is being prepared. And when it is prepared, remember, at times it was not using proper, clean, hygienic elements there, including water. And with the result, whoever consumed it, whoever taken it, whoever drank it, naturally had a right to go to hell once for all. Now, to avoid from this, remember, the state of Guatemala prepared an infant formula. Having prepared an infant formula safely, it started administering it, and proportionately the deaths had come down. And proportionately, when the deaths had come down, remember that company which was selling so much of infant formula in this country lost the business. When it was about to lose the complete business in that country, it influenced the government of America. And the United States naturally interfered and went to the extent of pointing out, remember, the ad which you have given for the infant formula is the infant formula which is being given by the company, and you have violated the copyrights. And you have to close this. And if you don't do, naturally, you will have no business with us, and we will take care of you and send you. Now, ultimately, it had to be closed, and the government of Guatemala had to suffer. Now, this is one instance I am telling you. Guatemala had suffered because of this in another instance, because related to part of environmental law. I just intend to bring home this as well. Now, what has happened was, in 1 year, in the state of Guatemala, the production of bananas came to, remember, zero. Because there was a particular pest, and this pest had entered and spoiled the entire banana crop. Now, immediately the government of the Republic went to the extent of going to some of the companies in the state of United States. And these companies were asked to prepare a particular pesticide. And this pesticide, which is known as capone, was prepared. And the capone, after manufacture, was sealed in separate, remember, containers. And the heading showed exclusively prepared under the orders of the state of Guatemala. And it came to the port of Guatemala and airports. And the people the previous year had suffered, go there and collect it. And having collected, remember, without going through the label and other things, they started spraying it. And remember, the very first day of payment, some of them started getting pain. Some of them get, remember, headache. And some of them other diseases. And in 1 week, a few of them got paralysis. And ultimately, the diseases which are yet to be discovered, and they passed away. And this is because, remember, government gives the order and they make the manufacture. And this manufacturing of pesticides, whether it is useful to the Republic and what are the inherent dangers of it, are not even being told to them. Before using them, what they are supposed to do or not to do. These are not informed. One sociological cause I just intend to bring home here. Now, what has happened was nearly 1,349 women, when they go to the social court and ask for divorce because the husbands had become impotent by using this capone. This is the order of the day that is happening. Now, another instance happened in an instance, remember, in the 90s, AIDS has become common in some of the African countries. And remember, it was just like a savage hitting everyone and killing and eliminating everyone. And it infected with the entire African continent, barring a few. In circumstances such as this, what has happened was the African continent wanted to, remember, solve this problem, and they approached some companies in the West. And the Western companies, they said, we will prepare a kit. And this kit containing drugs to prevent the disease of AIDS would cost you $13,000 to $15,000 in a year. $13,000 to $15,000 in a year. And they started administering it. So the point at issue is some of the economies in Africa and their per capita income was, remember, just $50. And of the $50, if they start, remember, investing on to save the lives of these innocent people by $15,000, there is nothing required. Anything is not required for the liquidation of a particular government because of the lack of interest. Now, this is how it has taken place. At this juncture, what has happened was some of the manufacturing companies from India enter into the arena. First, and they go, and some other countries as well. Having gone there, they just look to the medicine. Having gone to the medicine and the contents and the substances which are being used, they said it can be prepared, and they started preparing it, and it was a good cure, and they started selling it as well. And remember this much, they started selling it at $230 per kit, per year, per person. And where is $230 or $250? Where is $13,000 to $15,000? Imagine. And a question was put to the developed countries and these organizers. And when these organizers were put a question, remember, they met in London. All the general managers or the directors or office bearers, they came and met, and afterwards, in the end, they, in a press conference, said, we are not bishops into business. What do you mean by that? We are not bishops into business means only bishops, remember, give everything and they don't take everything. This was the attitude of multinational corporations in the situations of this kind. Now, similar things happened even in other instances as well. Now, for example, South Africa, when it was infected with AIDS, what has happened was a particular British company came to the spot, and having gone to the spot, they prepared and sold to save their place for $600. Now, the same product was prepared as a generic drug by some of the companies from India, and later they had to withdraw because of the pressure of the company from United Kingdom and United States. They said, you don't have an IPR. Since you don't have an intellectual property rights, you cannot, remember, do these things. Now, having said this much, I just intend to speak to you some of the deficiencies in the definition of IPR itself. Now, you might be knowing when I speak about the definitions of IPR, what is indicated there is, first and foremost, to get an intellectual property rights, there should be a discovery. And then there is, see, first one is, it should be original. And you should have an inventive step. And it should be capable of industrial use. It should be original. It has not been done by anybody. It should have an inventive step, how it is being done. And it is capable of industrial use. Some of the writers in the area of IPR pointed out that in the TRIPS agreement, the explanation that is being given to this, the very definition of intellectual property rights, especially on these matters, which I said, discovery and invention is incomplete. Now, they don't say what exactly is discovery. Well, in one sentence or two sentences, they will say discovery, and for invention, the same thing is being followed and kept. Now, because of the ambiguity, because of the lacuna, because of, remember, not expressing it very clearly, what has happened was, at a later stage, patenting of life forms were recognized. You may be knowing Diamond versus Chakravarti. After Diamond versus Chakravarti, for the first time, it was recognized patenting of life forms. Now, when patenting of life forms was given, remember, naturally biopiracy used to take place. And when biopiracy used to take place, remember, it was not able to protect. And especially countries, developing countries like India, are the victims of these, is the point which I just wanted to bring home. Now, having said this much, now the entire WTO is based on 3 principles. Now, what are these 3 principles? First one is non-discrimination. And the second one is what we call as prohibition of quantitative restrictions. And the third one is most favored nation treatment. Now, non-discrimination, entire WTO is based on non-discrimination. What do you mean by this? Now, if you allow the goods of somebody to your country, without a tax regime, you have to allow the goods of other countries without a tax regime. There cannot be discrimination between 2 states who are members of WTO. If the goods of one country go to another, and that country prefers only your goods, that cannot be accepted. All. If you accept the goods of one country, you have to accept everything from the other country as well. Then this is not discrimination. There cannot be. The principle of equality. That was what is being pointed out. Then thereafter, prohibition of quantitative restrictions. Under no circumstances you can put prohibition on quantitative restrictions. If quantitative restrictions are put, remember, the whole WTO has no meaning for its functioning. Then the other one is most favored nation clause. What do you mean by this? The most trade treatment which is being given to a particular state is to be extended to others also. Now, when I speak, suppose, for example, amongst the Arab countries, in the Arab countries, between the Arabs, we have all the treaties depend upon most favored nation treatment. Because if a benefit is given to one country, all the Arabs are entitled to, remember, benefit from this. But this same benefit cannot be accepted or given to a non-Arab country. For example, I remember, because I was serving as an advisor to the government of Bahrain in the cabinet. Now, when there was an investment treaty with the state of Pakistan, being an Islamic country, they would extend certain benefits to the state of Pakistan. On giving or extending this benefit to Pakistan, the state of India cannot claim as of right. And if they give, it is fine. If they don't give, you cannot claim it. But then non-discrimination has to be followed in stricto sensu. For this purpose, the WTO came to be established. Now, one important point I wanted to bring home is the entire, what we call as the TRIPS agreement, is not based on public welfare criteria. Anywhere, any constitution, remember, any legislation, when it makes or when it's passed, public welfare criteria has to be adopted by it, and it should go through this process. Now, what has happened was the Human Rights Commission, the Subcommission of United Nations Commission on Human Rights in the year 2000 pointed out the clauses or the articles within the TRIPS agreement are a violation of the basic human rights. And they are not supportive of the basic human rights which are fundamental to every citizen. I shall just explain to you so that you understand the point better. Now, the one important development happened to be, for example, the right to life. The right to life is an essential fundamental right, especially when you go through the Constitution of India, you get to know, you come to know, and you know what exactly is this right. And the right to life has been, remember, interpreted by the Supreme Court several times, and many rights came under the umbrella of the right to life. Now, first right happened to be the right to food. Then came right to medicine. Then came right to good health. Then the right to wholesome environment. And remember, all these are, many are added as and when the Supreme Court felt like adding. Now, I am just putting a question, or the authors put a question in saying, Now, all these are not part of the TRIPS agreement at all. If, for example, when I speak of public welfare criteria, first one is the government should see that the medicine is available. And then it should be in a position to give the medicine at an affordable rate. And if this is not done, remember, the whole thing, the whole concept gets defeated is the fundamental point which I am just harping for a purpose of discussion. Now, that is where the WTO has become a weak organization. Now, having said this much, I just intend to speak to you something relating to the WTO, what we call as the mechanism within the WTO. I just said GATT did not have what we call as an enforcing agency. And you have an enforcing agency under the WTO. Now, in the enforcing agency, you have the first one is, for example, what we call as the enforcement mechanism. Now, in the enforcement mechanism of WTO, all are treated equally. All are entitled to make use of their rights. Now, the point at issue is, now first one is, remember, before the panel discussion, there will be a submission. And when once the submission takes place, naturally, remember, they will say whether it can be accepted or not. And thereafter, it goes to the panel, and from the panel, it goes to the appellate body. Now, the expenses that come in, I'm just telling you the point. The expenses, remember, naturally come in are more than $500,000. So from the entry level to the final level, 3 stages you have. And if you go to the appellate body and a decision when it is given, remember, it will be almost $5 lakh in one case. And just put a question to yourself. How many of the developing countries are able to go and argue the case? And especially if the matter is finished in the appellate body, minimum this much. And the advanced countries, remember, they have the money and they have the people to defend. They have the legal experts. And all of them, right from stage 1 till stage 3, they are in a position to amass and argue in their favor. But one important thing is, in spite of these things, many of the cases are won by the developing countries. Now, to take an instance, I just intend to give the statistics. Till 1995, from 1995 to 1999, 2000, till for a period of 5 years, there were as many as 179 disputes which came before the dispute settlement body. Of the 176 disputes which came before the dispute settlement body, most of them are won by the least developed countries and the developing countries. But then at a later stage, what has happened is this is not happening. Now, the other thing I just wanted to speak to you happened to be a statistics that is being given. Now, the statistics that is being given clearly points out in the dispute settlement mechanism, in the first 20 years, that is from 1995 to 2015. Now, how many of them, who has filed, and who are the people who have filed the cases? Now, the statistics clearly points out, it is very interesting. The first one is United States of America alone had filed 104 complaints. United States alone had filed 104 complaints. European Union had filed 97 complaints. Canada had filed 58 complaints. Then Brazil 31, India 23. Now, these are the 4 countries which are involved in serious disputes with the WTO. I am putting a question, where are the other countries? 25% of the WTO is constituted by the advanced rich countries. And another 25% is constituted by the least developed countries. Of the 50 developing countries, only India and Brazil are able to go and see that dispute settlement mechanism is first is resorted and sorted and decided by it. So this is the sad state of affairs, because no least developed country can afford to pay $5 lakh, remember, for the settlement of a dispute. Initially, what we have stated in the objective of the World Trade Organization is to promote trade and non-discrimination, without discrimination between the developed and developing and the least developed countries, and the least developed and the developed. Is it happening now? Now, having said this much, I can just tell you an instance which has taken place during the COVID crisis. During the COVID crisis, for example, you take an instance relating to what we call as masks, ventilators, and oximeters. Mask, ventilators, and oximeters, naturally, most of the countries are not in a position to prepare. And initially, remember, although we imported, at a later stage, we were able to manufacture. But then, as far as ventilators are concerned, we had to remember, for oximeters also, we have to rely on developed countries. And whenever this question came, the question of IPR came to the surface. And when it came to the surface, naturally, remember, they refused to give. And even, for example, I just wanted to speak about you, for example, manufacturing for the entire thing would cost you so much, and it will liquidate the economy itself. Now, for example, one instance happened to be the N95 design of masks. Now, to the moment we asked for N95 masks, they said it is only for use, you cannot produce. And if you produce, it will hit under the Designs Act. And if it hits under the Designs Act, the penalty will be very severe and you have to pay huge money. With the result, we have to, remember, divert our activities to some other and prepare what we call as masks. So is the case with the ventilators. And you just see the ventilators, how much it was costing. It was costing so much of money, and least developed countries will not be in a position to prepare. Now remember, the role of the WHO is also doubtful. It was not supporting the least developed countries. If it were to develop the least developed countries, remember, the medicine, especially what we call as Covaxin, which is produced by the state of India, could have been given permission for production for the whole world. They went to the extent of pointing out you can produce only in India. And when once you have India, you can manufacture you can export it to some of the developing countries. This was the attitude, and this attitude is not appreciative of the WTO. Now, for example, when we wanted to have full production, they said it is not possible. And they said we have to consult the WHO and other countries. But then what they have done, and these countries, when they wanted to manufacture, they approached the companies and the scientists who work for the companies. And afterwards, they said, you produce the medicine, and once the medicine, we will be in a position to make use of it. So before that, they went to the extent of giving $15 to $20 billion in the state of the United States and subsequent states for the companies. And afterwards, investigation or research began, and they produced. And when they produced, the bulk drug was actually bought by them, and they could not give to anybody. Are they giving it today? Where is the World Trade Organization? Now, these are certain things which I just wanted to bring home. There are many more. And I just intend to thank everyone for giving me this opportunity to highlight. If you have any questions, I shall try to answer if I know.
Thank you so much, sir, for such an insightful session. I would like to invite Dr. Balaji, sir, for questions.
Sir, we have few questions from the.
Okay. You read it for me.
We have from Dr. Narendra Nagrawal. So,
Okay.
How WTO policies have affected India's social protection policies especially the exploitation of agriculture sector?
Yeah. Well, see, most of the things on paper, they will speak about equal treatment, equal protection, and other things. But then the social protection clause, when it comes to the intellectual property rights, are defeated. And it is the policy here and there. Because of the contacts and other things, a country may get the benefit. But even there also, they will be waiting for a chance to bounce on these developed countries and developing countries, including India. Now, for example, when Trump was the president of the state of the United States, they wanted to give certain things, but they postponed. And this postponement, remember, naturally it took almost for 6 or 8 months. But then when they came to know that India is going for some other greener pastures, they said you can take it. But then IPR issues naturally will be there. And I don't wish to take up issues and speak on this, because on that part I have not prepared. Don't intend to spread false knowledge.
Okay, thank you, sir. We have one more question.
Yeah.
From the Santosh Upadhyay, Professor Santosh Upadhyay. In the midst of emerging nationalist tendencies across the countries, what do you think the future of multilateralism in trade? Whether WTO could cater the development needs of developing countries without compromising their sovereign choice to regulate their own resources in their own way?
Now, since the question is asked, I should just tell you, in the year 1960 itself, the United Nations adopted a unanimous resolution. Each state is competent to exploit its resources by itself. And there cannot be any interference in the name of neo-colonialism by other countries. But then this is only a resolution which was adopted unanimously. And thereafterwards, remember, in the year 1974 came in what we call as the new international economic order. And it went to the extent of pointing out there is a duty on what we call as the developed world to support the developing countries and the least developed countries in the growth of their economy. Because for almost hundreds of years until 1940 or 50 or 60, these people were taking the resources and becoming rich and richer. In circumstances such as this, there is an obligation on their part to develop the economy. Now, there are plenty of resolutions which are adopted to this way. This is because of the pressure that was on the rise from the developing countries and the least developed countries. But then what happens is today, now no developing country or least developed country can survive by itself. And when it is on the mercy of the developed countries, naturally they are being exploited. Now, the important part to the story is even there is no unity amongst the least developed countries. I just told you, even in the WTO, only 23% of the cases are taken by the state of India as the representatives of all the developing countries. I still remember, if you go to the Law of the Sea Convention of 1982, remember, all the developing countries wanted India to be a leader, because by then only non-aligned movement had died its natural death. In situations like this, remember, unless each country determines itself to promote and to progress and to prosper, you cannot rely on others. For example, I will give the latest information what is happening in the state, the fight between the two countries. The other country is demanding, and whenever it demands, the assistance is being given, and assistance, when it is given, they say, we have given 50 million worth. And then they say, we have given 75 billion worth of arms and ammunition. What it means? That it means it is going to be counted on such poor state. And it may have to pay through its nose, although, remember, when the economy is completely ruined. This is the natural answer.
Thank you, sir. We have one more question.
Yeah.
From Sahid Raja. So he's asking how our country will counter the decision of WTO, Trade Dispute Settlement Panel, as the domestic support measure for sugar and sugarcane are inconsistent with the global trade norms to the final authority, that is WTO appellate body.
Now, the point at issue is, suppose, for example, I will give an instance as well. Now, in the WTO, first stage, plenary stage, and then panel, then afterwards dispute settlement body. And the dispute settlement body gives the decision. And when it gives a decision, remember the point it is, how do you enforce? This is the question which came in. And this is the question which is going to come there also. Now, first is the retaliatory measure you have to take. And retaliatory measure, if you have to take, remember, it should be strong. Now, can a country is empowered or willing to take any action against the state of United States when the decision is forthcoming or decided by what we call as the dispute settlement body, appellate body? In one case between the state of Barbados and Antigua and the state of United States. Remember, ultimately the matter went to the first stage. When it came to the second stage, a judgment was given in favor of Antigua and Barbados, a Caribbean country. And afterwards, the state of the United States appealed to the appellate body. Having appealed to the appellate body, remember, America lost the case and Antigua and Barbados won the case. Now they say retaliatory measure. Antigua and Barbados are small islands in Caribbean. Now, what retaliatory measures they can take? And the state of the United States started browbeating, simply saying from how it can implement. This was the sad state of affairs under the WTO, which is going to happen to every country, even within the subcontinent.
Thank you, sir. One more final question.
Yeah.
Is there anything to protect discoveries and innovations under TRIPS other than patent?
The point at issues, as I mentioned to you, that is why I raised. Now, this has to be answered as of now by them only. Because since it is stated there, since the TRIPS agreement is part of the WTO, because once you become a part of the WTO, when you ratify it, TRIPS are part of it. Now, the process of changing this has to come through public opinion and writings. And unless you do that, it is not going to happen. And for which, remember, majority of the developing countries should see that it happens, and they should be in a position to sponsor it and support it and move it and see that it goes before what we General Council as well as the other Ministerial Conference of WTO for its adoption.
Thank you, sir. Simran? Simran?
Now I would like to invite our Program Director, Professor Anupam Jha, for vote of thanks.
Good evening, all of you. We have now reached the concluding part of today's special lecture on WTO and developing countries. On behalf of Law Center 2, I would like to propose a vote of thanks to all our speaker dignitaries and organizers who played a great role in making the day truly memorable. My heartfelt thanks to our guest speaker, Professor T.R. Subramanya, for his kindness to grace today's occasion and share his thoughts on the topic WTO and developing countries with us. He has rightly charted out the evolution of WTO and how sovereign countries joined this organization. Joining WTO is also very important. India has been the member of WTO for a very long time, since its inception. And many sovereign countries, now we can say that even countries which did not like free trade, they have also joined this WTO, which is based upon the principle of free trade. WTO does not promote the principle of mercantilist, nationalist, chauvinistic trade policies, but it is promoting the free trade principles, whereby the trade restrictions on trade through different means, as Professor Subramanya said, quantitative restrictions, import licenses, those should be done away with. And therefore, it is a good point today to understand, as Subramanya also said, that many countries have joined the WTO. Ukraine had joined. Ukraine is now war-ravaged and sufferer. Ukraine joined the WTO in 2008. And before that, China had joined it. And 10 years back, Russia also joined WTO. So you can see that how WTO has become important for countries like even the socialist countries or so-called different countries which follow different, not democratic principles. So many sovereign countries, most of the sovereign countries, they have joined the WTO, and they all have come to know that comparative advantage theory is very important for any nation. And when India had also joined this WTO in 1995, at that moment of time, the then Commerce Minister Pranab Mukherjee, he had also said that now India has come to understand that comparative advantage is good for India. And comparative advantage theory is the theory on which WTO has made many rules and regulations. So today's lecture by Professor Subramanya has highlighted the importance of the nations to join this organization. Otherwise, before this Second World War, because GATT, first of all, GATT was established, means GATT was not an organization. It was an agreement. It was an agreement on tariffs and trade. So this agreement was concluded because before the Second World War, the countries, they had been following these nationalist policies and very narrow principles of trade, mercantilist policies. So this needed to be changed. And today we can see that this has, although this is not ideally been successful, but still to a great extent, WTO has tried to, encourage the principles of free trade. Professor Subramanya also highlighted about the importance of negotiations. And WTO does not take away the right of sovereign countries to negotiate on many issues. And therefore, when he said that the Uruguay round, which started in 1986 and which continued till 1994, how important were that round? Uruguay round, how important was it? That many issues came up for the first time during this round. And he rightly said that, intellectual property and what we say services and investment, these were the new issues which came up during this round. And therefore, there was a great expansion in GATT. And now we have so many, additional agreements which have been annexed in WTO. But the importance of negotiations, that was highlighted. And therefore, what we can say that the developing countries like India, they have taken advantage of this position in which they have tried to hardly bargain from the developed countries. When there was Doha round, when there was Bali round, Nairobi rounds, in all these rounds, you could see that India and developing countries, they wanted that there should be a fair share in the trade, and that should be fair on the basis that agriculture, which was a taboo for the developed countries, that agricultural issues, that should come on the negotiation table. And many commentators from the developed countries, they said during the Doha round that the developing countries are trying to, spoil the whole game of free trade. But still, Indian leaders, they held the ground and they said, no, we will have to do something for our poor people so that they would not starve in the situation of, flood, in the situation of drought, in the situation of COVID. And therefore, we have now the stock holding programs. We have now the Food Security Act, and which will not violate the WTO principles that we should know. We should acquire the agricultural products from the farmers at an administered price. So these are the issues which are important when you go for negotiation with the developed countries. Developed countries know the game, and developing countries are still learning the rules of the game. But now we are also in a position to, play well. And it reminds us the movie of Amir Khan, where it was depicted that how player like Amir Khan, he had to play with a player from England. So you see that the importance of negotiations has been highlighted by Professor Subramanya. And I am so thankful to him for that. He also explained about the decision making through the Ministerial Conference, General Council, specific councils, and the Secretariat on different areas. And on this, developing countries have also tried to, move through the decision-making processes. And of late, in the Corona times, India has tried to move a motion in the General Council and in the TRIPS Council that there should be some waiver on intellectual property rights for use of vaccines and for the use of, as Professor Survania said, about use of and trading in masks and oximeters, N95, etc. So now this is taking a long time. India and South Africa, both these countries, they had moved this motion before the TRIPS Council, and now it has been still being discussed in the General Council. And now our minister says that whenever the Ministerial Conference would take place, which was due to take place in 2021, and now which will take place perhaps in this year, so then they will take it up in the Ministerial Conference so that this motion will get through. But it is very difficult. It is proving to be difficult. How the developed countries, even in the face of Corona times, they are still reluctant to waive off the intellectual property rights for the use of vaccines and many life-saving drugs. Now that need to be seen. So it was important that Professor Subramanya highlighted that how the decision-making at WTO takes place. And I am thankful to him. He also highlighted the importance of the dispute settlement body. This is the first institution which was made to resolve the trade disputes. And this institution was not fully functional during GATT period. So this DSB is very important. And this DSB is also used by developing countries. And Professor Surmanya highlighted that how much amount is spent in the dispute resolution, like $5 lakh are spent in the dispute, which may go up to appellate level. And he also said that despite this less strong economic position, developing countries have also won many cases, which is a positive sign. And but sometimes you can see that the DSB, which is composed of panel and appellate body, and appellate body is a standing body, and appellate body has, it has all the judges, and they are working on the permanent basis. Our Ujjal Bhatia was there for a long time in appellate body from India. But of late, in the last 2-3 years, appellate body has become so weak and now it is not functional. So why is it? Developed countries, they do not like appellate body. And in United States is the leading example, which says that no, many judgments from appellate body has been against us. They do not favor us, and it takes long time that trade disputes are being resolved. Therefore, we are not going to appoint any judge in appellate body. So, this kind of, we can't say the rift, but we can say there is a gap of approach between the developed countries and the developing countries. And that can be seen there at the dispute settlement level also. More importantly, Professor Subramanya highlighted the linkage issue, where he stressed the need to de-link labor from trade, to de-link environment from trade, and so on. He said that to de-link intellectual property rights from trade, and also to de-link health from trade. He iterated that these are not healthy signs of WTO's health. And he said that TRIPS should take care of public welfare also. So it is very important that these should be de-linked. But nowadays, it can be also thought that when the world is becoming, connected through trade, and when some countries, they do not even, they are not having the primary sector of what we say like industries, where they can, go for the agriculturally finished products or, packaging of the food items. Now, in that case, they have to import it from other countries. And in that case, what they have to they have to think that the imported products, they should be, free from any kind of, bad things, like it should be hygienic, it should not be, unhealthy. And therefore, they can put, many like sanitary conditions, phytosanitary conditions. And sometimes also to discourage such kind of trade where human trafficking takes place, where such kind of, abuse of labor takes place, bonded labor takes place. There, it is the duty of the countries at the world level to link labor with trade. And when the climate change is happening, then we should also decarbonize our economy. In that situation, we should also, encourage to link environment with trade. And intellectual property is still debatable, but because of the fact that a lot of investment takes place in the promotion of, new drugs, not generic drugs, but new drugs, in that case, the link with intellectual property, that may also not be far-fetched. So that is one thing, but this was important that what Subramanya said, that TRIPS should take care of public welfare, and life-saving drugs, generic drugs, should be kept outside the purview of TRIPS. And therefore, what he said, that the need of developing countries to acquire drugs for health of its citizens and to raise the standards of people, those are very important, and those have been the objectives of the WTO. Further, Professor Subramanya also highlighted the basic principles of WTO, such as non-discrimination, most favored nation, and no quantitative restrictions. Now, these are important pillars, and these important pillars are relaxed in favor of the developing countries. So when we talk of Article 1 of GATT, where most favored nation is being dealt, then we can also look at Article 20, and thereafter, many exceptions are there. And some exceptions are that when there would be a kind of, situation where problems like monetary problems of any country, then that can be relaxed. And non-discrimination principle, like national treatment, which is dealt with in Article 3 of GATT. Now, it has also different rule for the developing countries, and what we call like the principle of GSP, which is not liked by developed countries led by United States. And recently, you might have heard that how during the times of Mr. Trump in the US, how he was saying that India should be deprived of this developing country tag, and now it should be not dealt with under the relaxation clause. So these are some of the gaps between the developed and developing countries, which were highlighted by Professor Subramanya. Only stressful thing is the relation between India and Pakistan, and Professor Subramanya has been there at Bahrain, and he might have seen that how difficult is the position between India and Pakistan to deal with. And you see that this most favored nation and all these basic principles, which should have been, promoted by these two nations. And there is a specific clause in GATT which promotes, some kind of, economic integration between India and Pakistan, but that has not been possible because of the huge political differences between the two leadership of our countries. So I'm thankful to Professor Subramanya for highlighting all these issues, and today our students must have benefited from his special lecture, but I should not forget at the same time to give vote of thanks to my beloved professor in charge, Professor Mahavir Singh, who has worked day and night to lift our center, Law Center 2, at a higher level. And today's event is also been made memorable because of his welcome note. I must congratulate him for successfully organizing this event despite some initial technical hiccups. He has taken a lot of pains to improve even the administration and overall academic strength of our center. His style of functioning collectively is very famous, and under his guidance, as he was telling that various committees of Law Center 2 have been functioning very smoothly. It's really a proud moment today that Law Center is also celebrating 50 years of its establishment, and how different programs are being organized frequently at our center. I must thank all members of organizing committee of today's program, namely Dr. Balaji Nayak and Eklavya Anand, without whose sincere efforts today's program would have been absolutely not successful. They have been working for making this program very successful. And I'm also thankful to Ajay Sonamane, who has made this program technically successful. This program is being live on YouTube and many other social platforms. So I extend my heartfelt thanks to all the learned faculty members, and more importantly, the students of Law Center 2 and of other centers also, because I know that students from other centers have also joined, and this webinar is therefore today successful. I hope that your participation will take this Karwa far ahead in days to come. And last but not the least, Delhi University Computer Center also deserves special applaud, because they only give us the link for this Zoom, which is now serving this program. So at the last, I'll say Jai Hind, and thank you so much for having this program. Thank you.